Welcome to our conversation, The Black Church, the Death Penalty, and Intellectual Disabilities. This is a conversation that I've wanted to have for a very long time, as more states are bringing attention to outdated, unfair, unethical, and unchecked ways the way capital sentences are being applied to people living with intellectual disabilities in our country. I am joined by a qualified, distinguished leader who I believe has over about 30 years of research and experiences in death penalty data, public policy, faith inclusion with the conversation with me. I want to start with a couple of definitions for our audience just to make sure we are all on the same page. Capital punishment. Capital punishment is defined as the legal authorization of killing someone for a crime. Intellectual disabilities, a disability that affects the acquisition of knowledge, skills, more specifically, neurodevelopment conditions affecting intellectual processes, educational attainment, the acquisition of skills needed for independent living and social functioning. Severe mental illness. Severe mental illness commonly refers to a diagnosis of psychotic disorders, bipolar, social anti-personality disorder, and or either major depression with psychotic symptoms or treatment-resistant depression. Faith inclusion. Faith inclusion includes including the members of all faith communities in social justice movements. So now that I've covered this conversation, let's jump right in the conversation. So I'm going to start by introducing Robert Dunham. Robert, thank you for joining us.
My pleasure.
Robert is an attorney and nationally recognized expert on the death penalty. Robert served as the National Death Penalty Information Center's executive director from March 2015 to January 2023. Before joining DPIC, he was one of the leading capital appellate lawyers in Pennsylvania, arguing on behalf of the Commonwealth's death row prisoners in its state and federal courts and in the United States Supreme Court. During his tenure as executive director, DPIC produced groundbreaking reports, many of the reports I've used in my research in public education, on execution secrecy and race, and the U.S. death penalty modernized its awarding website. DPIC also assembled its death penalty census of more than 9,700 death sentences imposed in the U.S. in the past 50 years, the most extensive database of its kind. Mr. Dunham previously served as director of the former Pennsylvania Capital Case Resource Center and director of training of the Capital Habeas Unit of the Philadelphia Federal Defender's Office and as assistant federal defender in the Harrisburg Federal Defender's Capital Habeas Unit over the past 30 years. Mr. Dunham has taught in death penalty training programs offered by national and state and local courts, bar associations, and professional organizations, and spoken at numerous national and international death penalty conferences. He is now the executive director of the Death Penalty Project. Welcome again, Rob, and I'm just going to begin with our first question. Why is intellectual disability becoming increasingly popular in death penalty cases and policy issues?
Well, I'm not sure that I would necessarily use the word popular, but it is becoming much more prominent. And part of that is the movement we've seen across the country, where some of the more conservative forces have been trying to undo constitutional protections and undo civil liberties. The United States Supreme Court, over the course of the last 50 years, has slowly, piece by piece, said that the death penalty can't be expanded, needs to be contracted, used less frequently, and used in a more careful way. In 1989, in an Oklahoma case, the defendants tried to get the United States Supreme Court to say that the death penalty was unconstitutional as applied to individuals with intellectual disability. I'm sorry, I said Oklahoma, I meant Texas. Penry versus Linaw. And in the Penry case, the United States Supreme Court recognized that a person's intellectual disability, it was known as mental retardation at the time, a person's intellectual disability was something that you had to consider as a reason to spare a defendant's life. But they said, no, that's not a categorical exclusion. You can execute people with intellectual disability. In the years that followed that, more and more states agreed that somebody who is as intellectually vulnerable and vulnerable in the court system because of their diminished intellectual capacity, that wasn't the type of person who should be subject to the death penalty. And so in Atkins versus Virginia, the United States Supreme Court said, you can't use the death penalty against people who are intellectually disabled. Well, there are two very critical votes in the Atkins decision. One of them was Justice Kennedy, One of them was Justice Ginsburg. And after Justice Kennedy's retirement and Justice Ginsburg's death, uh, Donald Trump replaced those justices with much more conservative, much more right-wing justices who don't agree
Hmm.
with the limitations on capital punishment. So today, and that's for people who are watching this later, I'm talking about January 19th,
Hmm.
2023, the United States Supreme Court is actually conferencing, considering whether to hear a case in which Alabama is trying to undo the constitutional protections
Right.
that the Supreme Court issued. Now, the reason this is so controversial is because after Atkins, states that wanted to execute people with intellectual disability came up with ways that they could go ahead and do it anyhow.
Right.
The way they did that was in Georgia, they required defendants to prove that they're intellectually disabled beyond a reasonable doubt.
Hmm.
That's way beyond what the medical requirement is.
Right.
States like Florida said if you have any test score that is above 70 on an IQ test, we're not going to look at whether you have significant impairments in the way you function on a day-to-day basis. That's not the medical definition.
Right.
And that enabled people who were intellectually disabled to still be executed. And then Texas created this thing that they called the Brasenio factors, which is named after a case with a defendant by the name of Brasenio, that let the courts look at a whole range of lay stereotypes to figure out whether somebody would be deemed intellectually disabled. And the court said in Moore versus Texas, essentially, that's crazy. That's crazy. Whether a lay person in Texas would think
Right.
someone with intellectual disability has got nothing to do with whether you're intellectually disabled or not. So we're seeing all of these little things that are very important that are making it so that people who are intellectually disabled are still being executed. And I think one of the most pernicious things that we've seen is prosecutors' use of experts who are using what are called ethnic adjustments.
Mm.
The ethnic adjustments take a look at IQ scores and use a different set of norms. Norms are what you judge an IQ based on. You take a representative sample of the community and see what their scores are. They want to take a different sample of the community, and their ethnic adjustments would make it so that you have a different score if you're African American than if you're white.
Wow.
What that essentially means is there are people who would be deemed to be not intellectually disabled because they're black.
Mm.
And if they were white, they wouldn't be executed. And ethnic adjustments are also being used in determining whether someone has deficits in their day-to-day functioning. And all the time that you use these, quote, ethnic adjustments, what you're really talking about is racial bias and racial stereotyping designed to make it so that individuals of color can be executed in circumstances in which you wouldn't be executed if you were white. That's, I think, why it's so controversial.
It's absolutely controversial, and I'm glad that you brought up the ethnic adjustments. That's something that I think many people don't understand and they don't know about. So that's something that I believe that this webinar will offer to folks to get more involved on a state level of what's going on. I am here in Atlanta, and you talked about the burden of proof that we are currently dealing with right now. We've been dealing with it for a number of years, and I serve on a team of really great minds who are challenging the elected officials to really look at that, while also simultaneously working with prosecutors to make sure that there are no objections to the bills that are being proposed. So we are still on the battlefield here in Georgia. Now, I'm originally from Memphis, Tennessee, and I was privileged to be a part of the legal strategy team for Purvis Payne. And Purvis Payne in Memphis, Tennessee, the Tennessee Assembly passed legislation designed to prevent death row inmates with an intellectual disability from being executed. And this happened in April 2021. And then on August 30th, 2023, the Tennessee Criminal Court of Appeals affirmed a lower court's ruling that Purvis Payne can serve his 2 life sentences concurrently, making him eligible for parole, to apply for parole in less than 4 years. This was a fight in itself, but it also became a movement in Tennessee. Because for those who are not familiar with Purvis Payne and his family, he came from the Black church, one of the largest Black denominations in the country, the Church of God in Christ, is where his family was from. And myself, his attorney, Kelly Henry, Kim Kia Harris, and others, Andre Johnston, and folks that were on the ground in Memphis were very pivotal in not just rallying for justice for Purvis Payne, but also educating the community about intellectual disabilities. So this gets me into my next question. What cases involving intellectual disabilities stand out to you? And I know you're also familiar with Purvis Payne's case, so feel free to go more in depth with that case on your end from a research perspective.
Well, let's start with Purvis Payne because I
Okay.
think I think his case may well be the most important intellectual
Right.
disability case since Atkins itself, and it's critical to our understanding of the criminal legal system and how individuals with intellectual disability are so disadvantaged in it.
Right.
The miracle is that Purvis Payne is still alive.
Hmm.
And that's because the courts have set up and states have set up so many obstacles to being able to even get your claims heard that when the claim is heard, it's sometimes half the battle.
Right.
With Purvis Payne and with the state of Tennessee, the way the state law was set up was you had one opportunity after your conviction had been upheld on direct appeal. You had one opportunity to raise new claims.
Right.
And so Purvis Payne had that first opportunity, I believe it was before Atkins was even decided, and the state courts upheld his death sentence. After Atkins was decided, he wanted to say, look, I am intellectually disabled. I am not subject to the death penalty. And Tennessee had no mechanism
No.
to allow him to do that. Now, you would think that if there's no mechanism, but it's unconstitutional, courts would step in and say, wait a second, I don't care what your structure is. You can't execute Purvis Payne. You can't execute anybody that the Constitution says is not subject to the death penalty. But that's not what happened. The state court said, we have no mechanism, and therefore we're not going to look at the case.
Mm.
And because of the strength of the community and the legislative response that was a product of the strength of the community, a new law was passed that created this mechanism. And it's only because of that that Purvis Payne is alive. His execution was scheduled. He was going to be executed.
Yeah.
And because this legislation was pending, his execution was put off. And then um, the day the law became law, Kelly Henry and the Purvis Payne case was in court with his claim, and eventually he won. Now, even that is an understatement of how complicated it is, because states have no interest, no legitimate interest in carrying out unconstitutional executions. And there is no interest, no legitimate public interest in denying a person who is intellectually disabled his or her day in court. And yet, without any evidence that he wasn't intellectually disabled, the district attorney's office, the state attorney's office, continued to oppose getting Purvis Payne off of death row. And in fact, that was part of the reason why the black churches in Memphis and civil rights leaders in Memphis opposed the reelection of the district attorney
Yeah.
and won. So there is now a new district attorney who is more interested in actually enforcing constitutional liberties, constitutional rights. And so, if you can't make change legislatively, or you make legislative change, but local actors are still more concerned with using the law to harshly punish people or using it as an instrument of social control than they are in promoting social justice, it shows the importance of the community in getting involved and changing who the local officials are. So I think those are some of the key lessons from Purvis Payne's case. But another important thing still to remember is, with all of what we've seen that was good in Purvis Payne's case, this gentleman is innocent.
Right.
He is still in jail.
Yes.
He has not been exonerated.
Yes.
He needs to be exonerated. So we have to keep working on this case. And the fact that Purvis Payne hasn't been exonerated points to something else that we see with individuals with intellectual disability and some of the other really important cases, like the case of Henry McCollum and Leon Brown in North Carolina. These two gentlemen, both of whom are not just intellectually disabled, they are profoundly intellectually disabled. They were convicted of the rape and murder of a young girl. And it was a horrible crime. It was a crime so bad that the Justice Scalia in the United States Supreme Court used it as an example of why we need to have the death penalty. Well, we don't need to have a death penalty that is putting innocent people on death row and may result in their death. The courts in North Carolina did not grant relief to Mr. McCollum and Mr. Brown. It was only after North Carolina created an innocence commission that the case ever got the review that was necessary. And these two men, eventually, after the courts had failed, got a recommendation from the Innocence Commission that came forward with evidence that they didn't do it. And their intellectual disability was part of the reason why they were unable to get the relief in the state courts. They were not able to effectively communicate with their counsel, and they were provided lousy lawyers.
Yeah.
So that's this is something that we see all the time. It disproportionately affects defendants of color. It disproportionately affects those who are poor. And 80% of the people who have been intellectually disabled and have been executed are individuals of color, 2/3 of them Black. And 80% of the individuals who have gotten relief after Atkins have had their unconstitutional death sentences overturned, have been people of color, and 2/3 of them have been African American. The question of intellectual disability and the death penalty highlights what we've known all along, which is that the death penalty is disproportionately applied against those who are most vulnerable and those who have least power in society.
Absolutely. The intellectually disabled community holds a special place in my heart and other communities that are vulnerable because oftentimes I believe, and you can disagree as well, that the legal community sometimes doesn't even have the proper knowledge and education to represent individuals that are intellectually disabled. They don't know what to bring, they don't know what to look for, they don't know what to discover in those cases. So that's kind of part of my challenge in this work is for the legal community, but not just the legal community, the faith community, be aware and work with partners that work with individuals that are intellectually disabled. And oftentimes, sometimes intellectually disabled individuals are mixed up or confused with folks with severe mental illnesses. So that's why I wanted to begin with those definitions as well, because we often hear, they knew what they were doing, or this is a person that hasn't been diagnosed with something, so they still should be, tried for those crimes. And that's just absolutely unfair and unethical. And in Memphis, like you mentioned, it was a twofold. It was prosecutorial ethics and responsibilities, but also advocating for an innocent man who has not been exonerated in the state of Tennessee. So thank you for elevating those. And I'll be sure to have links in this email for folks to do more research on. So in
Well,
2020,
if I can step in there for a second, this is
sure,
really
sure.
important. This is really important, and I absolutely agree with what you've said. So there's more to be done,
Mm,
and one of the places we need to start with the legal system is the failure of the indigent defense system.
mm,
Right? Most states, and I think I'd be probably safe to say every state uh,
mm.
that that has the death penalty has a deficient indigent defense system, and it becomes all of the problems with it get exacerbated, get worse when you come to issues like intellectual disability.
Right.
When you have poorly trained and under-resourced lawyers, they, one, don't know what to look for, and two, even if they did, they don't have the resources to properly do the investigation. Even now, more than 20 years after the lawyers are on notice that an individual with intellectual disability can't be subject to the death penalty, we see cases in which lawyers think that IQ tests are all you need. And we see lawyers who take it, here's the IQ test. They take it at face value without
Face
understanding
value.
the way that IQ tests actually work. One of my first intellectual disability cases was a gentleman by the name of Simone Perella, who was intellectually disabled, spoke no English, and was illiterate in Spanish. And he was represented by a court-appointed lawyer who didn't meet him until the Tuesday before his trial was to begin. Now, you have something like that, that it'd be impossible to develop an appropriate defense based on
Absolutely.
intellectual disability. But even then, when he had an IQ test, um, people needed to understand that they gave him a Spanish-speaking IQ test that was normed against a population in Puerto Rico, which is where he was from. It wasn't, the lawyers didn't know that you have to use American norms to assess how somebody functions intellectually in the United States. And the test that they used inflated his IQ scores by almost 20 points.
Mm,
So we had to come in and get a Spanish-speaking neuropsychologist to do appropriate testing. We had to get an expert in testing techniques to explain how the test didn't mean what people thought it meant. And that's a problem all the time. The way tests are done, and no one quite understands this particular phenomenon. If you norm a test, let's say in the year 2000, But you give it to somebody 10 years later,
Mhm.
their scores are going to be higher than if you gave it to them in the year 2000. No one quite knows why, but for the last 70 years, there's been this persistent um, phenomenon that's called the Flynn effect because it was discovered by a psychologist named Flynn that
Mhm.
shows that IQ test scores rise by an average of 3 points in the course of a decade for an old test. You have to use the most recent test and you have to use the most recent norms. Well, where that comes in, why that's so important, is that states like Florida and Kentucky and several other states have said, well, if you have a score of more than 70 on your IQ test, we're not going to even look at
Yeah.
other evidence that you're intellectually disabled. And so, because the wrong test was administered, or because the lawyers didn't know that you have to make adjustments in the scores to account for this phenomenon, you have people who are intellectually disabled who are still being executed. We have
Yeah.
28 people who are intellectually disabled who've been executed since Atkins. And it is poor defense representation that is responsible for much of this. It is lawyers who just think he doesn't look intellectually disabled. So I'm not even going to look into this. He seems like he knows what's going on, so he can't be intellectually disabled. It's this bias that makes people think that people with intellectual disabilities are vegetables, and
Mm.
they're not. People with intellectual disabilities can do amazing things,
Right.
but they have significant impairments in understanding and significant impairments in day-to-day living. But it doesn't make you a vegetable. And because of these stereotypes and because of the lack of training and the lack of resources, people are still being sentenced to death and still being executed. And here's another place where the church and the community is really important. Once you get over the first threshold, which is showing significantly sub-average intellectual functioning, the lawyer for the defense has the obligation of showing significant deficits in adaptive functioning, in day-to-day functioning. And that means that we have to come forward with the evidence that we have. And so folks in the church community who know the family can talk about the ways in which this child, the person as a child, didn't understand stuff. How when they were playing sports, couldn't quite get the rules. And over you could explain it to them, but still didn't know. You hit the ball, you run to first base, you don't run to third base. Things along those lines. How the community has rallied behind the family, and so taken care of this kid in a lot of different circumstances. But he can't live by himself. We've made food for him. He can't cook for himself. A
Right.
whole range of stuff like that. He gets from place to place, but guess what? Other people are driving him there, or he can drive to places that he's familiar with, but he can't read a map. And if you want him, if he's going to take himself or somebody else somewhere that he's unfamiliar with, he's getting lost.
Mhm.
I mean, all these basic things that the community knows and the community can come forward with, and people who have been helpful to the family, or in the case of broken families, that things that they have observed that just nobody has said to the lawyer, and the lawyer
Yeah.
doesn't know is important. It's critical that the community be involved.
That's so important. And 28 people with intellectual disabilities have been executed since Atkins. That's very, very pivotal, and it really sticks out to me. And I thank you for creating empathy for our audience and giving folks kind of a day in the life of someone with intellectual disabilities, because you may have one idea in your head and it's completely different. And what you did is you removed the stigma and you gave examples of how someone with intellectual disabilities experiences the world. And I'm sure the intellectual disabilities community appreciates that, because we have folks that are part of our community within flocc that are part of the intellectual disabilities communities and advocating for them. So thank you for humanizing them. In 2021, I organized a group of Black clergy, policy professionals, attorneys, and organizers together to extend the access of policy, execution, legal, and also policy information directly to Black and Indigenous pastors. I wanted to gather this group together because often we, as policy leaders or attorneys or organizers, we call on them sometimes at the ninth hour. And we call on them when we need them to stand on the steps of Congress, or when we need them to sign a petition or a letter or attend a vigil and be a speaker. But we really don't invite them in on any type of participatory policy processes or any type of education that gives them more information to bring back to their communities and also bring back to their congregations. And I want to empower and embolden Black and Indigenous clergy who have often been at the forefront of a lot of social justice movements. We're in January 2024, and we just celebrated one of the largest faith and justice leaders, Dr. Martin Luther King Jr., a couple of days ago. And with that spirit, flocc is fueled by that spirit of him, Dr. Martin Luther King, Ida B. Wells, and others who stood on the front lines of social justice movements. Flocc is compelling the church to pay more attention to these cases. They are not so cut and dry. The criminal justice movement has been booming in the last couple of years with folks talking about ending mass incarceration, bail reform, youth justice, mandatory minimums, and capital punishment sometimes get lost in the shuffle of that conversation. And I believe at the height of the carceral system is the American capital punishment system. And we have to talk about the capital punishment system more and everything that intersects fiscal responsibility, race, innocence, intellectual disabilities as we are having this conversation right now. Rob, you answered a lot of the questions that I already have on here, but I do want to ask you, what are some of the states that have addressed ID in death sentences recently? Do any states come to mind that we need to flag for our audience? They may be in those states or they may have connections to those states.
Well, there are a lot of states and the federal government,
Right.
because because the death penalty is unconstitutional for individuals with intellectual disability. We don't need to flag the states that are doing it right.
Right.
We need to flag the states that are doing it
Doing
wrong.
it wrong.
Uh, and and sadly, that's basically all the states that didn't want Atkins to be decided the way it was in the first place. So states have been developing all sorts of hurdles, throwing all sorts of hurdles at providing the constitutional protections that are necessary. I think Florida stands out.
Florida always stands out, doesn't it?
Yes, it does. And in fact, Florida has executed more people in violation of the Constitution proportionally than any other state. Texas has executed more people unconstitutionally, and a significant proportion of them. But Florida is the worst. And in Florida, there have been recent laws that have been passed that make it easier to send people to death row and make it more likely that individuals who have intellectual disability are not going to be able to have their death sentences overturned. Florida was one of the states that I mentioned earlier that had this 70 IQ cutoff. If you didn't have a test score under 70, that was it. And so it has executed a number of people who are intellectually disabled because of this medically inappropriate rule that that you aren't intellectually disabled because you had a test score that was above 70. Ron DeSantis, the current governor, has appointed new members of the Florida Supreme Court, and they are far right-wing justices. All of them were recommended by the Federalist Society, and they are very activist judges. And what they did was, after the United States Supreme Court struck down Florida's 70 IQ cutoff, the Florida Supreme Court said, okay, fine, we're going to allow people to go back and come into court and litigate their cases. And the new Florida Supreme Court said, no, we're not. So you may have raised your claim of intellectual disability, and we may have unconstitutionally rejected it using an unscientific, medically inappropriate standard. But guess what? Too bad for you.
Right.
So that's something where we need to be standing up, and we need to be trying to get the legislature to do the right thing and pass a law that says if you're intellectually disabled, you cannot be executed. We don't care about whether your claim has been, quote, procedurally defaulted.
Yeah.
I think Florida is an important state to address that. Also, we need to be very careful in Florida because now, even if one-third of the jury votes for life, the judge can still sentence you to death, which is astonishing. And it is particularly dangerous in cases of young African-American defendants who are intellectually disabled, because the way juries are selected, if you are opposed to the death penalty, you are stricken from the jury. If you have a religious belief that there is a merciful God, and as a result of that belief, you will not impose the death penalty, you are stricken from the jury. And we all know from years of experience that what that results in is a jury that is whiter and a jury that is more male.
Mm.
And a Southern all-white or a Southern mostly white, mostly male jury is a jury that has historically been extremely prejudiced against defendants of color. Well, when we think about the way that that society misperceives young Black men, young Black kids, adolescent kids, it's really dangerous. And if that person is intellectually disabled and they harbor the jury harbors misperceptions about intellectual disability, and we already know that juries, and specifically white juries, are much more likely to treat a young Black kid the same way they would treat an adult. It's a process
Mhm.
that's called adultification. They are much more punitive in the way they treat these kids. Well, given this 8-4 jury vote and the exclusion of African Americans from the jury, both because of this death qualification process and because prosecutors then, after that, use their discretionary strikes disproportionately to remove jurors of color. I think we need to bring a lot of attention to that, and we need to put a lot of pressure on locally elected state attorneys in Florida that they should not be using the death penalty in questionable circumstances. You know, there is no legitimate interest in seeking the death penalty against a person with intellectual disability. And if it's a close case, if you're going to make a mistake, you shouldn't err on the side of punishment and social control. You
Mhm.
shouldn't err on the side of, well, we're going to try to kill this person who has intellectual disabilities. Maybe it's not enough to be considered intellectually disabled, but they still have diminished intellectual capacity. If you're going to make a mistake on the side of life.
Yes.
And I think we need uh, in Georgia, we need to be behind the law that says if the medical community believes that somebody is intellectually disabled, they should be treated like they're intellectually disabled.
Yeah.
Georgia law, in every other area of the law, follows the medical definition of intellectual disability. It's only when somebody's life is at stake as a defendant that they create this higher burden of proof.
Right.
That's completely inappropriate. So I think we need to be paying attention to that. And across the country, Alabama is a big example of this. Prosecutors who are using the death penalty as an instrument of social control
Yes.
and an instrument of excessive punishment are trying to roll back protections. In the case of Mr. Smith, whose case is before the United States Supreme Court today, Joseph Smith,
Yeah.
they are saying, let's roll back these protections. Let's make it so that the evidence that would prove intellectual disability doesn't even get considered. That's inappropriate. And these are the same prosecutors who are supporting rolling back voting rights. They're supporting allowing partisan gerrymandering. They're supporting limitations on women's health care. They're supporting limitations on citizens returning from prison being able to vote. I think that it's important to understand that what's going on with the death penalty is part and parcel of this current national effort to roll back protections that we have fought for generations to get.
Generations.
And so the death, if you allow these kinds of injustices to occur when it's a matter of life and death, then they're going to occur in other cases as well. So it's important that the death penalty be included among the things that are critical to protect when we're thinking about not allowing our civil rights and our constitutional rights to be rolled back.
Oh, Rob, I hope you detected earlier my gentle sarcasm because we agree on a lot of policy issues.
Yeah,
When you began to speak, there was this rage that began to fester in me because I felt that we are still fighting the same fights that our ancestors and folks that have come before us have felt like they've already fought.
yeah,
And what we are here to do is to build upon that work. But when we have to go back and sustain the work that has already been done, that's kind of where that rage is coming from. And that's why we need all of you to engage in this movement with us. You talked about jury disqualification in Florida, and that's not just Florida, in a number of states. We talked about the adultification of children. We talked about innocence. I don't know if we hit on this, but also Florida last year with last year with the non-unanimous jury.
that's right.
Like those are all things that we need to be paying attention to. It's not just about the death penalty and executions if someone commits a murder. It's about all of the social determinants that are included and why people seek death sentences, and why the system itself needs to be challenged because it's gone unchecked for a very, very long time. And I hope those who are watching are activated to join us in the movement. I know that something said by myself or my guest, Rob, was compelling and thought provoking enough for us to get involved on a state and also federal level. We name many of the states that some of you all reside in. And if we didn't, if you're in a non executing state, there are actions on the federal level that you can get involved in. So, attached to this webinar are further links and research that you can get involved in to be mobilized. I would be remiss if I didn't mention EJUSA's Evangelical Network. The manager, Sam Heath, he has a toolkit for churches and religious institutions to get involved in to be able to teach and understand the application of scripture and also the death penalty. So, Rob, I do want to ask you as we close,
Mhm.
how can people follow you and what initiatives and or projects are you working on that we can track?
Well, my new death penalty policy project, we will soon be launching a website. It's going to be a not very well developed website for a while, but it'll eventually get there. I have a Substack, the DP3 Substack. We've posted a number of things there. Most recently, a report on how states that have the death penalty are actually lagging behind the rest of the nation in gun safety,
Mm,
and still have higher rates of gun violence. I have a Twitter feed, or X, whatever you want to call it now, which is at R Dunham DP, where I post breaking stories every day that deal with capital punishment, and I consult on a regular basis with community organizations, with death penalty abolitionist organizations, with churches, and so forth. So you can follow me on Twitter. You can send me a note. They can send you a note, and you can get to me. There's one thing that I wanted to say before we close. It's paraphrasing one of the heroes of our movement, Brian Stevenson.
yeah.
Brian talks about how the death penalty is a descendant of slavery and lynching and Jim Crow segregation, and all of the data back that up. But there's a recent study that was done that I think may cast it in a slightly different light. It isn't that it is a descendant; it's a manifestation of the same phenomenon.
Mm,
A new study that was done at the University of North Carolina shows that there's a geographic relationship between where lynchings took place, where the death penalty is being used so much, where we have this ongoing racial resentment, I think is the phrase that they used. And it is the same communities and the descendants of the same people who are fighting the same battles that we are fighting against. I think that we have to be we have to be vigilant. We have to be smarter than they are. We have to work harder than they do, and we have to want justice to prevail more than they want justice to be defeated.
mm,
And the community is the core of where our strength in the civil rights movement comes from, and it is our moral compass. So when we're looking for where the strength of the moral compass comes from, we're looking at the church. And that's why I would implore everybody who is listening, and everybody who is involved in the social justice movement. We're not going to give up. We can't give up. We've come too far, and we're not going back. But we're going to have to keep working hard, and we're going to have to keep working harder.
Rob, thank you for grounding us with those words. We have to be vigilant, but we also have to be responsive. There are actions, there's work to do. We know you enjoyed this conversation that we had, but we definitely need you to act. We need you to follow Rob on Twitter, X, send me emails. I always have one on ones with faith leaders throughout the week when I'm able to. Again, I want to say thank you so much to Robert Dunham. I will be stalking the website, making sure that I'm the first one there when it is launched. And I just want to say follow Block Justice on all social media platforms. We're on Facebook, we're on Twitter X, we're on Instagram. And also visit blockjustice.org and sign up for our mailing list to stay up to date to all the actions that Flock is working on. So I will say, In joy, in justice, and in dedication, thank you for joining us on this call. Until next time.